I have 7 o'clock. I'm going to call the meeting to order and join me with the pledge of allegiance to the flag.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good evening, everyone. Roll call.
Mr. Volker.
Here.
Mr. McAdams.
Here.
Mr. Ford.
Here.
Mr. Kangro.
Here.
Mr. Jenk.
Here.
Everyone is present.
Everyone get a chance to read the minutes of last meeting?
Yes, sir.
Yes.
With any additions, corrections?
No.
I didn't have any. No.
Do we have a motion to accept them?
I'll make a motion to accept the minutes as recorded.
I'll second it.
Roll call.
Mr. Volker.
Abstain.
Mr. McAdams.
Aye.
Mr. Ford.
Aye.
Mr. Kangro.
Aye.
Mr. Jenk.
Aye.
Motion is passed. For future reference, if you missed a meeting, you can vote on the minutes. There may become a day that we may have 3 people here, and one might miss the next meeting, or that we might have replacement of members. So you can. It's okay to abstain, but if we need.
You don't have to.
But if we need the vote, you can.
Okay.
Gotcha. Good to know.
All right, that's new.
All right, I'll make a motion that we go into executive session pursuant to Ohio Revised Code Section 121.22G as follows. Number 1, to confer with an attorney for the public body concerning disputes involving the public body that are subject of pending or imminent court actions pursuant to Ohio Revised Code Section 121.22G3. Do we have a second?
I second.
Mr. Volker.
Aye.
Mr. McAdams.
Aye.
Mr. Ford.
Aye.
Mr. Kangro.
Aye.
Mr. Jenk.
Aye.
Motion passes. We are in executive session. Which means we go to an executive session and then return.
like to call this meeting back to order. And I would like to make the statement that we're here to hear about the height variance only. We're not here for any other, like Clatty Road, we're not here to bring up Clatty Road. We're here for the height variance of the building. So if you have comments on them, on it, you're more than welcome to make comments. All right, is there anybody here? What, let's head first.
Did you want me to go first?
Yep.
Yeah, read the memorandum.
Just to kind of recap, the case here, we're looking at a variance request of 6 foot 3 inches for a storage structure. The maximum height for storage structure is typically 20 feet per the code. The property's 720 Barge Salt Run Road is also accessible, and at one point had an address off of Clatty. The parcel number is listed in here in the zone R1. The site's located here on the map. You can see the zoning of the site R1, and everything around it's R1 or estate residential. Where this little three-dimensional box is approximately where that structure is located. This was the site plan. You can see the building built in the middle, and you can see the building plan on the left of the slide, and the chariot that was there on the right, and its chariot is 19.5 feet tall. This is the structure as you're looking at it. We looked at all these pictures from other areas. That's the chariot itself closer. We had some questions, issues related to Clatty that we talked about. I'll come back to that in a minute. In the last meeting, the board wanted us, the staff, to look at the prior cases and the conditions of approval. And so I prepared a memo for the board. From the previous conditional use approvals associated with the property, only one case, which was case 9-18-A, was ever actually permitted for zoning permit and built. That was the only one, and that was for a gazebo that was in the, I think it's the playground area for the, near the temple, for the kids. All the other cases that did have conditions attached to them, the gazebo case did not. There was never a permit issued, and the structure in question or addition in question was never built. And so therefore, those approvals and those conditions expired because they're only good for 1 year. They have to get a permit within that year. If it doesn't happen, were court cases involved with the first couple of cases, but at the end of the day, when those were all said and done, they didn't get them permitted, so the conditions and everything expired because they were never built. We did receive an attached letter from Mr., and I hope I'm pronouncing this correct, from Mr. Ajay Munsif, President of the Executive Council of the Hindu Society of Greater Cincinnati, that reinforced the history and actions that I just talked about, and sets forth how the property owners intended to address the previous comments and recommendations by township staff in the last report from September. So I included that in your items that I sent to you other than the memo, basically. And then with respect to the required modifications, actually I have this on here for people to see. With respect to the required modifications, in the September 4th BZA staff report, the gate on Clatty Road did appear to be currently locked and closed when I visited it last, which was a couple days ago, I think. The area's been repaired. The missing loose dilapidated materials and sections and vegetation has been removed, pruned, and it appears to be in good condition, or it was the time I was there. I have pictures if you want to see them. Not sure that they're necessarily, again, relevant to the height of the structure, but they did address the items that were in the staff report from September. And then I have pictures from the inspection that I did the other day on the 24th. And you can see those in reference to how the chariot fits within the building. The applicant can actually move the chariot into the building. was something that we did talk about in a meeting that we had with the applicant representatives. And in short, we basically told them that there's some risk in putting the chariot in the structure since the structure's not totally been approved, but at the same time, you know, the building is there and its original intent was to keep the chariot from being out in the weather. And so when I went out there, what I did is I showed in the attachment of the memo the chariot picture from August 19th. So this is the chariot, August 19th. And then on November 24th, this is the picture of the chariot in the structure. And then in addition to that, I provided this letter that we received September 27th, which talks a lot about the history of the prior cases and so forth. I think that more or less summarizes everything that we have had since September to go over. Do you have any questions for me at the moment?
No, sir.
I do.
Yes.
When we last visited this case, my impression was that there were unfulfilled conditions that the applicant had not fulfilled, but hearing what you just said, that is not the case, correct?
Yes, because the
Okay.
only case that actually had a permit issued was the one for the gazebo, which was the only case that did not have conditions attached to it. So every other case that was heard had conditions, but there was never a permit issued and everything expired.
Good, thank you, thank you. I thought I heard that right. My question really was just to make sure everyone else heard that right.
Okay.
Okay.
Okay. Any other questions from the board?
No.
Is there anybody to speak in favor of this height variance?
Yes, please.
Up here and be sworn in?
I'm happy to do that. I'm the attorney. I'm just here summarizing the argument, but I'm still happy to be sworn in.
State your name, spell your last name.
It's Jeffrey Forbes, Forbes.
You solemnly swear testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead.
Thank you, sir. Again, my name's Jeff Forbes. I'm an attorney with the law firm of Wood and Lamping, here on behalf of the Hindu Society Greater Cincinnati, and I appreciate the opportunity to just take a few minutes. Based on what I've heard so far, I don't think we'll need much time, but I appreciate that what we're talking about tonight is just focused on the application that's before you, and that's a height variance for an accessory structure. I know you had a hearing back in September, took a lot of public comment. I had the opportunity to go back and review that. I've watched it. I'm familiar with what was said that night. And I think that's important because now that we're focused on what's really before the board, really all you have to do is look at those 7 factors that are in your zoning resolution of whether variance should be granted. And our position is that if you look back at the testimony that you've already heard in September, and you're welcome to hear more tonight. I've got folks here that can address any questions you might have. But really, even with just the testimony you heard back in September, you have all the information you need to grant the variance that's being requested. I don't want to take up a lot of time, but if you look at those 7 factors, you know, the first one is that the granting of variance shall not be injurious or to the area or otherwise detrimental to the public welfare. There was no evidence back in September that a height variance of this nature would have any detrimental impact on the area or the general welfare. Your code says you can't grant a variance if it would allow a use which is otherwise not permitted. That's not the case here either. You're allowed to have an accessory structure building on this property. We're just here for the height variance. Number 3 is that there have to be special circumstances or conditions related to this. And that's one, if you look back at what you heard back in September, you'll hear plenty of evidence about the special circumstances here. I mean, and I won't recap the whole thing, but you know, essentially what you have is an applicant who needed a building permit and a zoning permit. They came to the township to get assistance with the form. There were some honest mistakes made, both on the part of the applicant and probably on part of the staff that helped fill out that form because the wrong number got put. I think if you look at the drawings that you've seen as part of your packet, 22 feet is essentially where the eaves are. 26 is the peak of the roof. They looked, when they filled it out, they used the wrong number. Either way, we acknowledge we needed a variance to begin with. But they were issued a permit, so they built exactly what they proposed in the plan. And it only was after the fact that it was brought to their attention that that was improper. So there are some very special circumstances related to this. Proof of hardship. Again, you saw at the September meeting, and you can see actually from the photographs that you got to see again tonight. This is, if the variance is not permitted, there's really no way that they can house that chariot that they use as part of their religious services. There's just no way to do it. You've seen the height of it. The building that they proposed, while it seems like it's 6 feet higher than it needs to be, I think you saw plenty of evidence back at the September meeting that really the door is where it needs to be so that it can just really barely get through, and then you have to have sufficient structural, up on the roof for the rafters, I guess that is. I'm not an architect or an engineer, but whatever the beams are. So it may seem that it's high, but it's really the minimum of what was needed to house this. Granting the variance has to be necessary for the reasonable use of the land or the building. Again, you've heard plenty of evidence on that topic back in September that says if they don't get the variance, they can't do anything with that chariot, and it would have to be left out into the elements. Number 6 is really simple. The variance, it can't impair the supply of light and air to the neighbors. It doesn't. It can't increase congestion in the public streets. There's no evidence that having a accessory structure that's taller than what the code allows would have any impact on traffic. Can't be a danger of fire. There's no evidence of that. There's no evidence of any kind of public safety issue with this or any evidence that it would impair property values. And finally, the last factor is that it will not confer on the applicant any special privilege, and it doesn't. I mean, you have the variance process for a reason. Granting a variance in and of itself does not give anybody any special privilege. Anyone has the opportunity to apply for a variance. So again, we have folks here that are happy to answer any questions if you have any, but I think the facts are, the testimony that you heard in September is that really all the evidence that's related to the matter that's before this board would support granting the variance. I know you'll have an opportunity for more public comment tonight, so I would just ask to reserve a little bit of time to address any of the comments that are made. But with that, we would ask you to consider the evidence, the testimony you've already heard, grant the variance, and we're prepared for a decision tonight.
Any questions from the board?
No, not present.
Okay, thank you.
Anybody else to speak in favor of it? Hearing none. Is there anybody that's opposed to it? Come up. State your name, spell your last name.
Cody Moore, M-O-O-R-E.
Raise your right hand. You solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead.
First off, I want to thank the board for giving us an opportunity to talk, legal counsel for giving that statement. We have prepared a statement. I want to respect what you said earlier. I might skate the issue, but I just want to read the statement first. Mr. Ford, Mr. Kangro, Mr. Jank, Mr. Walker, and Mr. McAdams, we come before you today asking that you review the zoning code, facts, and evidence presented and rule accordingly. We are here because once again, our neighbors, the Hindu Society of Greater Cincinnati, cannot follow the rules. If they could, we would not be here talking about this case. The facts are, the Chariot storage building was not built according to the zoning regulations, nor to the permit that was submitted. According to the pictures that Mr. McCormick furnished, The variance was not needed as the chariot clearly fits inside the building and probably would have fit had the building been constructed per the code. Why is it that the Hindu Society of Greater Cincinnati cannot follow the rules? We continue to see a pattern of do what you want and then ask for forgiveness later. As for the Claddy Road gate, Claddy Road is not safe for any increased traffic then or now. The increased traffic due to the temple opening has put an increased load on the road and caused an unsafe condition. From early on, we had serious safety concerns due to the increased traffic load. There were numerous incidents, accidents, even tour buses coming down a 14-foot wide road to visit the temple. Everyone, except for the neighbors who live on this narrow, rural lane, has turned a blind eye to the safety aspect of this road, including the Hindu Temple of Greater Cincinnati. They constructed a new access road compliant with all standards and don't want to use it. The gate should be permanently locked down and used for first responders only.
Okay, you realize we're not here for Claddy Road.
I apologize. I said I was going to skirt in our statement, but if we could just continue the rest of the statement,
Go ahead.
I will. Thank you. The Hindu Society of Greater Cincinnati has always claimed that they want to be good neighbors, but their actions seem to be in conflict. The neighbors on Claddy Road want to be good neighbors, but we are currently being disadvantaged and put in unsafe conditions. Our request is simple. Please respect our neighborhood where we all live every day. Claddy Road is too narrow for a thoroughfare, and when used as such, provides an unsafe condition for all of us, especially our children. And for those who do not visit our street, on 11/12/25, the Hindu Society of Greater Cincinnati had a contract saw cut the driveway, pour 2 concrete pads, and run electrical conduit under the drive to supply power for the new power gate openers to be installed. Once again, disobeying this board's orders to comply with condition of the previous variances. At this point, the board, in my opinion, has no other option than to deny the variance requested in case 1-25-A and to find them in violation of the zoning code. The building at this point should not be taken down. Again, this is about safety, and this is the only thing this is about. We live on that road, and if we have a medical emergency, our families have a medical emergency, and there's 8 cars on that road, we're not going to get the medical assistance we need. This is very important to us, and it's a serious matter. Appreciate your time.
Any questions from the board?
No, I have none.
Mr. Walker? Mr. Ford? None? Okay, thank you.
Thank you very much.
Anybody else is speaking opposed to it? Come on up. State your name and spell your last name.
Tim Campbell, Campbell.
Okay, and you want to raise your right hand? You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead.
I've got a handout I'd like to submit for the record, if I could, please.
Okay, sure.
I made enough anyway. I was supposed to be here. Yeah, I know, I may have enough.
Thank you, sir.
Thank you.
Turn it on. So, I'll stay away from safety. It's actually in my opening remarks that I wanted to stay off of safety, because we've been beating on it forever. I think the points are made. I did include, there's two pieces here, right? One's a bunch of photos, including one of Claddy. I apologize, but it's literally my truck sitting on the road, and you can see, you can't get around it, right? So, but my approach this time, because I've lived in the township my whole life, grew up on Claddy Road, watched the temple being built. It's the 100 acres right across the street from my house. I watched it all happen. So I've got all the history in it. So I also took the time to read the judge's ruling on the variances and what happened with the variance. I think I've heard the argument that because there was no construction actually happening, that those variances were lifted. Frankly, I don't think it matters. So in my approach today, I took a legal approach. I'm not an attorney, but I took a legal approach. I read the stuff, and I read the ruling. I threw a bunch of it into AI to see what AI said about it, and frankly, I think the argument I'm making here is pretty compelling. So, I'm going to stay away from safety. I'm going to jump right into it, right? So if you go to the second page of the blue binder, which is my main argument, start with the outbuilding. It's clearly a zoning violation, period, right? Maximum height, 20 feet. Height shown on the improperly approved plan was 23 feet. The height actually constructed is 26 feet 3 inches, is a straightforward dimensional violation, period. Ohio courts have repeatedly held that administrative error does not legalize a zoning violation. The clerk's mistaken approval cannot supersede the zoning resolution and is irrelevant. Because the Hindu Society of Greater Cincinnati's actual building height exceeded even the plan, the applicant is therefore seeking a retroactive height variance, which carries the strictest scrutiny because the hardship is self-created. In every argument, self-created. This board, I believe, has two options. Deny the variance and require the structure to be brought into compliance. That effectively means removal or reconstruction. Approve the variance with conditions that protect public safety and the zoning code's intent. There is no legal basis for unconditional approval. Not an attorney. I believe that's true. I'm going to touch Claddy just shortly. Claddy Road cannot lawfully serve as a regular entrance. Claddy Road is approximately 14 feet wide in most locations. IFC 503.2.1 requires 20 feet minimum for fire apparatus access to assembly occupancies. The temple is an assembly occupancy. Therefore, the Claddy Road gate must stay closed on Knoxbach, emergency-only status. Claddy Road cannot legally serve as an entrance for regular traffic. The board cannot ignore the fire code. The township has no obligation to widen or upgrade Claddy Road for a private user. The applicant already possesses a compliant, engineered, safe entrance through Barksalt Run Road. These are enforceable safety standards, not opinions. Touch on McBride's ruling. The McBride ruling does not create a right to use Claddy Road as an access. Judge McBride's 2018 ruling overturned only the portion of the board's prior decision that forced the closure of Claddy Road Gate as a condition of an unrelated project. He did not grant the applicant any affirmative right to use Claddy Road, restrict the board from imposing reasonable safety-based conditions, override fire code or minimum road width requirements, or create any RLUIPA-based protection for driveway orientation. His ruling simply held that the closure was not necessary for that project. It did not and could not create a right to use an unsafe road for an assembly occupancy. In that ruling, the judge also has a reference to RLUIPA argument. RLUIPA does not apply to traffic patterns or preferred driveway orientation. Federal appellate courts are clear that RLUIPA does not regulate traffic, driveway access, or site circulation. I've included 3 case studies that basically says other religious entities have made the same argument and the courts held that it is not an RLUIPA violation. Secondarily, entering for a specific direction is not religious doctrine and is not protected by RLUIPA. Did a little bit of research on Hinduism here. It has been suggested that access from Claddy Road has religious importance because it allows approach to the east. This requires a factual correction. Hindu religion doctrine does not require eastern vehicular access. Vastu Shastra may influence architectural orientation, but it is not a mandatory religious ordinance. Many Hindu temples in Ohio operate without eastern approaches, including the Hindu Temple of Dayton. I've got 5. I've got photos for you. I'm showing you the Google Earth image showing how the approaches are not west to east based approaches. I also included photos of the Hindu Society of Greater Cincinnati and how the approaches from Platte and the approaches from Bark Salt are effectively the same. One ends up approaching from the north to south, the other ends up approaching from south to north. There's effectively no difference in how the approach to the temple comes. Look at the photos. A conditional variance or denial are the only legal defensible outcomes. Because the applicant is fully compliant and safe entrance on Bark Salt Run, and because Clatty Road cannot meet fire access width requirements, the most reasonable, lawful, and defensible action is, 2, if the board grants the height variance, it is required that it be conditional approval on the Clatty Rate Gate remaining in Knox box emergency-only status. That condition complies with fire codes, protects the public safety, consistent with zoning intent, avoids setting any unsafe precedents, does not infringe on any religious rights, aligns with all relevant case law, allows the applicant to retain the building while maintaining safety. This is the narrowest, most defensible path available. If the board denies the height variance, for sake of a complete and defensible administrative record, there is a second outcome that also preserves public safety and keeps the Clatty Gate Road restricted. If the board chooses to deny the variance due to the self-inflicted or self-created violation, the result would be that the structure must be brought into compliance, meaning removal or reconstruction with a 20-foot height limit, and the fire code would still prohibit the gate from functioning as a regular entrance. Denying the variance also maintains the current emergency-only status of the Clatty Gate. My conclusion, both legally defensible outcomes, conditional approval or denial, result in the Clatty Road Gate remaining restricted to emergency access only. The only action that would be difficult to defend under zoning law, fire code, or case law would be granting the variance without conditions or allowing Clatty Road to become a regular entrance. I did what I could to give you photographs supporting the argument, trying to stay away from the safety stuff because if you've ever been down there, it's just clear as a bell. So I invite you to come down, drive my truck, sit at the top of Clatty Road where it goes from 2 lanes to 1, and then watch what happens. I did it tonight. It's every day. So, by the way, one other comment. Before the Bark Salt Road entrance, Clatty Road was a disaster. I mean, you were in ditches, in driveways, you were all over the place. After Bark Salt, it improved dramatically. But the gate's closed. That gate opens again, it's gonna be bad, especially during a snow event or an event where they're just dumping traffic out onto Clatty. It's gonna be a mess. That gate has to be closed. Final point, it's a safety point. I know there's an argument that says the Bark Salt Road entrance is also dangerous because it's windy and it goes through hills and all that, right? Okay, fine, that's right. But what's more dangerous, and what should we do? Should we plow that driveway and put salt down, or dump all that traffic on the Clatty Road? It doesn't make any sense. That gate needs to be closed. Thank you.
Okay. Any questions from the board?
No.
No? Okay, thank you. Anyone else to speak against it? Hearing none. Discussion of the board.
How tall is the chariot? Do we know that?
Chariot,
19
19 feet.
6 inches.
19 feet, 6 inches.
They have not always had this chariot, have they?
Nope.
And prior to that, we approved one time an ash ramp.
I believe so.
Remember that?
I believe, I was on the board.
The ash
I
ramp
believe that.
for the fire worship. I guess what I'm curious is, with the number of deities, how many more other things might be down the pike for us to consider? Now, I know this has a bearing on this. I'm curious about that. I'm just wondering.
I don't see how that's it's somewhat along the lines of a self-imposed.
Yeah, I just.
I mean, can
I'm curious
a
about-
chariot be 18 feet, or can it be 17 feet?
Right.
Or is there a dictation that says has to be 19.5?
So we might need to bring someone up to
I have
find
a- I
out.
have a few questions.
Yeah.
We have a few
Maybe for
questions
the attorney.
from the Hindu Society. Somebody'd like to come up and speak on behalf of them on, we need to know some measurements of the chariot and et cetera. So if somebody from, you've already signed in, come on up. State your name.
Rajkumar.
You solemnly swear to tell the truth, the whole truth, nothing but the truth?
Yes, sir.
Okay, go ahead. Go ahead.
So how tall is the existing chariot?
It's 19.5 feet.
And is that dictated by the religion? Like the height
No,
of that?
there
or-
are chariots are anywhere from 12 feet all the way to 80 feet.
Okay.
So what, just out of curiosity, what came first, the chicken or the egg? In other words, did you buy the chariot and then built the shed for it? Is
We
that
bought, we,
I've had
we
the-
bought, we designed the chariot so that there is space for the priest to stand, two priests to be able to stand inside.
Okay.
That was one of the decision parameters. The other parameter that we gave was the width of the, how far the tires should be apart,
Okay.
the axle width.
Well, I think it's the height, where the height is now and where the latest photographs that shows the chariot in, it seems like there's ample room. And I think last. Go
That's
on.
because above, so we had 1.5 feet between the door and the chariot. That's what we left. And the center where you see, that piece is really 26 feet. So we really should be seeing the chariot right at the door and not where we are seeing at the center.
So would
So
20,
the other, I want to go back to the reasonings that we said. So we started out with the 21 feet, of which necessitated a leg height of 22 feet.
okay,
And then we wanted to add a rolling door that can go above, and that's what caused the other foot.
okay, well, the rolling door sits in a drum, I guess.
Yes.
Then goes out. So what is, I guess my question would be, what would be the least or the optimum height you could use right now? Because like I said, it looks like you have a lot of space there. I mean, if you lost 4 feet, would that create a problem? Does it have to be, the full height of 26 feet, or could it go down?
I just don't think we can add a door with less than 26. So so rolling door.
That type of door.
Right.
that
The
you're
type
talking
of door. So when we asked for a horizontal door, sliding door,
Gotcha.
our structural engineer said it might not stand because it's so tall.
Right.
He said it might not stand the wind speeds.
Okay. So you need the rolling.
That's what he suggested we go for.
But is that dictating the height of the structure itself is what I'm trying to get at? No.
Was there any
This is
consideration?
what we gave our engineer, that these are the design parameters we gave our engineer. And that's what the shed company designed for us.
Was there any consideration to like a shed roof?
So the slanting roof, you mean?
Yeah.
Slant back, and then you would still have the room for
They,
your door?
they felt that they could not do it at that height. That's essentially all that was there.
I know
If it can
plenty-
be done, I don't know.
I know plenty of buildings.
I'm
that
not an
height.
engineer.
I know plenty of
I'm an
buildings,
engineer, but I'm not a civil engineer. I've studied electrical
I
engineering.
know plenty of buildings that height that have a shed roof on it. I mean, that's not unique.
The other condition was the
But you don't-
rolling door.
But it doesn't take 6 feet, 3 inches to put that rolling door on.
It was 4 feet, 3 inches, I think, above the leg height. Yes,
And I have another question.
yes, sir.
you were given a variance of 22 feet. Why did you build it 26.3?
We, from the very beginning, our design document specified 26.3. We took the document to the office, and so engineering drawings apparently specify the leg height and not the rooftop height. So when we took the drawing to the zoning commission's office, the staff there who helped us enter the height saw that 24 by 20 by 22 height at the very top of the drawing on the cover page, and that's what that's where the 22 came from. I agree, it's my mistake. I should have caught the wrong number. I did not.
I think
But that doesn't answer my question. If you were only given a variance of 2 feet, why did you build it 6 feet 3 inches?
Sir,
But it wasn't a variance.
so
then.
from the very beginning, we had only designed for 26
Just to
feet.
correct what you're saying, they did not get a variance of 22 feet. There was a mistake in the office that
realize it.
allowed them to have 22 feet, but they did not get a variance because
They did not.
even if they built it at 22 feet, they would be in the same position and we would
You
still
pray
have to
back
grant
again,
variance
pray.
for the 22 feet, I believe. Is that not correct? I don't,
Yes, that's right.
that would be,
Sure, yes, in a way I'm saying is we never changed the document.
okay. But I,
So that's what I'm saying.
But in his opinion, he was given a variance for 22 feet.
well, that's fine, but
I-
why was
I-
it built?
I-
But that's not what,
That's not what I'm-
That's not right.
But it
That's
was
not what
built
I'm claiming. I
26
think we were approved for 22 feet. I agree. But from the very beginning, our intent was to build at 26 feet, 3 inches. Because that's the plan we submitted to the building permit also, for the building permit also, which has nothing to do with this.
Can I ask Mark, just to be clear, without having to dig back through this, when they submitted those plans, it was submitted at 26.3.
I don't honestly know what was
Do you know
submitted
that?
up front because it went to another staff member, but the staff member was trying to help them complete the application form, and in so doing, I think he's the one that put the 22-foot number on there. I don't know if he was looking at what you see there on the left.
exact drawing he was looking at, so, if you look at that, it says 24 by 20 by 20. This is the only drawing we have.
Is there an approved set of drawings from the, where it says,
It'd be in a permit, I would think that it'd be in whatever.
Yeah, we don't have the elevation, we
Yeah.
did not have the elevation attached to the,
So this is what we
Permit?
took in. This is what we took in. He entered this and gave it back to us. So we did not submit it to the zoning commission. We submitted this document only to the building commission.
I would note it's not unusual for us to not have a building elevation on an accessory structure. We usually just have them the applicant indicate what the height is. And so I think what happened was that was an empty field or blank, and the other staff member that was involved with looking this over was just trying to help them fill it in. As you pointed out, just because there's a clerical or administrative error doesn't mean it's a variance. But I think the point here is even at 22 feet, whether this would have been caught up front or not, they would still have had to come in for a variance anyways. It's just from the beginning, we would have all been hearing that they need a 6'3" variance and would be trying to establish, if that is a justified amount or not versus another amount.
Right.
The 2-foot administrative error is an administrative error. If, like let's say, for example, if the board were to affirm the 22-foot number, that would be a variance of 2 feet. The staff cannot grant a variance. You would be affirming the number that the staff gave as far as like an acceptable number on the application as a variance. But whether that number is 2 feet, 6'3", or something in between, it's a variance, and no matter, what that number is or whether it occurred before a permit was issued or later.
So just to restate what you just stated. So we would have had to come earlier rather than after the fact when the error was discovered.
Anybody else have anything?
Not for him, but we're still a discussion of the board. So here's my,
Right, that's what
So
I'm talking about, the board.
I've always been in the thought process of you can't grant something just a variance for somebody because you're gonna get pinned against the next case that if it's not all according to this book. And my problem with this is 431, it cannot be self-created. Well, he just said that you could buy that from anywhere from 12 to 80 feet tall. They bought one at 19'6". So that somewhat self-imposes their problem. Then if you go to 431B, as granted in the a minimum variance to accomplish their purpose. Well, I believe that the minimum variance could be 22 feet or 23 feet, whatever it takes. You could build a building with a shed roof that angled back that probably accomplishes it less than 26.
Basically, if you did your homework, you'd know you had a 20-foot max, and then you'd buy your chariot to fit the opening, or go in and get a variance, right?
You could.
I mean, go in and get a variance to get what size that you ended up getting, or work with that. That's how I'm taking it, where, you know, your line of
I
thought.
mean, that's just a couple thoughts I
Yeah,
have.
no, I get it. I mean, does everybody kind of follow that? Yeah. So,
Brian, you're usually, what's your thought?
No, exactly. I mean, the opening is 20 feet, correct?
Yes.
yes,
And it fits
I
through there.
believe Scott
Yes.
went and measured it today. He measured it before the meeting.
So that is that's actually the minimum needed.
Right.
and the only thing they need to do is put, say, a shed roof on it, whatever, pitch or whatever, and then it would have worked. But what I'm hearing is, I guess their engineer or someone said you can't do that, but I agree, I think you can do that.
I
Well,
think you can do that.
lots of places say lots of things because they want to design it the way they want to design it.
Right.
You're gonna have a problem. So we're at 20 feet. You gotta have structure above
Right.
that.
Sure.
So you're gonna have to have, you can't lower it.
Right.
You know, so you're gonna have to, it's gonna have to be more than 20 feet tall, no matter what type of roof you have on it.
Correct.
You could, if he's saying that the drum door has to be taller than that, there's exterior style, or you could even do the exterior
Do barn
types of
doors
doors,
or-
because they do that on aircraft,
Hangars.
the hangars. And so that's what we have to consider. I mean, do you want to turn it down flatly, or do we want to make some, meet halfway in the middle? I don't know what the answer is.
I don't know.
Well,
Does that, I mean, you see, as far as the structure, that's,
I wouldn't have a problem with 22 feet.
I don't know if it could be done in 22 feet. I would think it could be.
if the opening is to what we just said with the door,
I don't
that
know.
drum roller's got to be at least, for the drop on that thing, at least 3-4 feet round diameter.
But what if you used a different type of door?
Exactly, which goes back to the airplane hangar kind of door, or another type of door, or even a rolling door that opens up, or something, that's on the ground. But, I mean, I look at it like the location of where that shed is, or the garage, so to speak, is kind of like off the way, So it's not like it's in someone's face. And as for the other comments that I'm hearing, like about the road, that has no bearing on this.
We're not talking about Cloudy Road.
Well, yeah, but I'm just saying that what we're doing here has no bearing on what's going on, a lot of the stuff that I heard. And that's a separate issue, in my opinion, that needs to be addressed elsewhere.
Right. Sir?
I
Sure,
come
come up.
forward.
You're still under oath.
Yeah, I'm not here to argue anything. I just genuinely, I thought Cloudy Road was a condition of being this granted. That is now not the case.
Clyde Road has nothing to do with the height of that building.
But in general, wasn't there conditions to get the permit? And Cloudy Road was part of those conditions? That's the only reason I'm asking is, I was under the impression that they had to perform certain things to get this permit, and Cloudy Road was part of that.
Not that I know of.
What they applied for was a simple zoning permit, and so for a simple zoning permit, that's not something that we would normally attach as a condition. The Claddy Road issues where there were conditions attached were on all those other cases that had come before the Board of Zoning Appeals.
And you're saying those are expired now?
Yes, and I didn't know that without doing some legwork, because I've only worked at the township for about 3 years, and
No worries at all.
all those cases were further back. And so between me doing research and them also providing information on their end, we found that the only thing they built was that gazebo that's over in the children's playing area, but that one didn't have any conditions attached to it. All their other applications did, but then they never built it, and they have a 1-year period for both any variance, like if any variance is granted, they have a 1-year period to make something happen. If they don't file for a permit within that 1-year period, they lose the variance unless they come back to the board to try to get it back. With the permit being issued, they then have 1 year to start construction and basically 2 years to finish. None of that ever happened on any of those other improvements.
Okay. Thank you so much. We appreciate it.
All right, did you have something you wanted to say?
I just wanted to make one point before the board gets to its decision. You'll see in your staff report, it's really clear that the decision that you make tonight has to be based on the evidence and the testimony and the findings of fact. And there's been a lot of discussion just among the board about whether it could be 22 feet or 20, however many feet, or what kind of door. Your decision has to be based on the testimony and the evidence that's already been presented, either tonight or at the September 18th meeting. And the only evidence that was presented, and reiterated again tonight, is that is the minimum that they could do. Based on what their structural engineer said, that's how tall the door had to be, that's the clearance they needed for the type of door that was on the application, and that's the structure that was needed above it. That's the only evidence and testimony that you have before you to make a decision. So we just ask you to keep that in mind.
Still doesn't say that whether they made their own
Well, they obviously did. He just testified to that.
right.
Right.
It is possible to buy a chariot 12 feet to 80 feet.
Right.
They bought one that was 19.6.
So they could have an 80-foot one, and we would be looking at
A
an
90-foot
80-foot
building.
variance.
Right.
They had to put a little light on the top of that one.
Any other discussion?
Where? I'm sure I know the answer to this, but we're under no obligation to ever grant any variance, are we? It's not like there's some rule that says because we are the board that does it, that we in fact actually have to do that.
No, I think the short answer is no, but the little bit longer answer to that is the zoning resolution, which has been adopted by the trustees, outlines the variance process and also, the conditions that you are, or the standards that you are to consider in doing that. But it's your guys' purview as an independent public body to essentially weigh the evidence in front of you, put them against the standards that are in the zoning resolution, and then make a decision. But it doesn't, it's not like an automatic approval. It's your guys' the administrative deference given to you all to essentially weigh the facts, apply it to the factors that Mr. Forbes went through, and I think are in the staff report, to go through. But if you guys determine that these factors aren't met, right, and in weighing the evidence, then that would lead presumably to approving the variance request. And if you determine that the facts and evidence before you aren't supported by those standards, then you guys can modify it, deny it. It's certainly within your guys' statutory power. So.
Thank you.
So would you say the facts are that they came in and applied for a variance to the drawings? That's the fact, right? Which was 26 feet. That's the fact. So I guess the way I'm taking all this is you either agree, that's the fact, or we can,
I mean, I also
modify
believe
it.
that typically we would grant a variance almost up to 25%, which would be 25 feet. It is close to that.
Yeah, and I mean, had nothing, and I get the chariot part, in hindsight, if they bought that first, back to what I said before, but that's not part, as I take it, unless I'm wrong, that's not the fact.
They bought the chariot first.
But we also had the guy that bought the RV that wouldn't fit in this building, and then wants to build the building,
Right,
like, it doesn't make any sense.
it's self-imposed.
Yeah, there's not a hardship that exists here
No,
that wasn't at all times in control of the applicant.
No, but they applied for 26.
but it
26
wasn't
feet.
approved.
No, I understand that, but that's what they came in and applied for. As for the other guy, I have no idea about that case. But I'm just thinking out loud.
I have a pretty interesting point of fact.
Yeah.
Come on up here. You're still under oath.
I apologize, I'm the historian, or one of them anyway. In the September meeting, I think there's testimony that said they had to buy it at 19.6, that it wasn't optional. Now, today, it's now 12 foot to 80 foot. In
Right.
September, it was 19.6,
Right.
religiously. That's why I made the point on RLUIPA, right? So the sands shift, the stories change, they don't follow the rules. So, but I want to make that point that September, one story, today, a different story.
Okay.
Thank you.
I would like to state, formally, I don't think this question of it being hanging to be 19 feet ever came up in the September meeting, to my recall. If people had asked me at that time, what's the minimum height of a chariot? I still don't know whether it's 12 feet, it might even be 10 feet, but I haven't seen. I'm not a religious expert, okay? But when I say 80 feet, those 80 feet chariots are rare. They are in India, okay? And they are 1 in 1,000, okay? So I'm trying to give you the entire range, and I'm being very honest here.
Yeah, no, my point in asking you the question about the height was I was trying to ascertain something in regards to hardship.
So,
That's it. That
so
was my
I
only point.
think what that said was, given our wheelbase that we asked for and the height of this thing, then the chariot designer said it must be 19.5 feet. That's probably a statement I made, okay? But I didn't say that is the only height.
No. Thank you.
Any other discussion?
I don't have any.
Scott?
No.
I'm gonna
None
make
for me.
I'm
You
gonna
ready to make
motion.
a motion?
Yep.
I'm gonna make a motion. In accordance with Article 4, Section 430, 431 of the zoning resolution of the Board of Appeals, I would like to make a motion to deny the applicant's proposed variance request to allow for a 6-foot 3-inch variance to allow for an overall height of the proposed storage structure to be 26 feet 3 inches. I'm going to base this on Section 431 A, 431.5A that states that the hardship cannot be self-created, and that is backed up by his testimony that said the chariot could have been created at any height between 12 feet and 80 feet.
You're referring to 5D. There was a typo, just so you know. It's 5D, what you're talking, in terms of
5B?
D is in
D
dog.
as in-
Oh, D.
D.
Oh, I see that.
Yeah, we need to fix
D,
that.
sorry.
Does that conclude the motion?
Based
That
on-
that was every,
Evidence.
okay.
Based on evidence.
Evidence, testimony, and findings of fact.
Do we have a second? We have a
I'll
motion.
second it.
Who seconded it?
I'll second it.
Okay, roll call.
Mr. Walker,
Aye.
Mr. McAdams,
Aye.
Mr. Ford,
Aye.
Mr. Kangro,
Aye.
Mr. Jenkins.
Aye.
Motion passes.
Any other things come before this board? this evening?
However, I did want to point out to you that I have been sending you the draft text for the short-term rentals because that had also been something that came up at the September meeting. We are not finished with that work, but I'll keep sending you that text for you to look at, and if you have any comments on that, just email me or call me.
Okay.
I'll make a motion to adjourn.
Do we have a
I'll
second?
second it.
Roll call?
Mr. Walker,
Aye.
Mr. McAdams.
Aye.
Mr. Ford,
Aye.
Mr. Kangro,
Aye.
Mr. Jenkins.
Aye.
Motion passes. We're adjourned.
We're closed.